Mr. Biow Chuan.
So I declare my interest as a lawyer whose practice involves criminal law. I welcome the introduction of the Public Defender's Bill. In the course of my work as a lawyer, I find that many accused persons struggle to understand the legal process whenever they are faced with a criminal charge. Many times, they are not given a copy of the charge sheet and don't know what is the exact allegation made against them. They don't understand the concept of bail, and sometimes they just want to plead guilty without understanding the consequence of a criminal conviction. In fact, a few of my clients have informed me that when they are charged at the police station, it is a police investigator who had advised them on the legal process and what to expect when they attend court. Sometimes the investigation officer informed them that if they plead guilty, the police will ask for a lighter sentence from the court. So this is of course unsatisfactory because the interest of a police investigator is different from that of an accused person. Allow me to quote from a speech made in Parliament in February 2013 by my former parliamentary colleague and the current Deputy Attorney General, Mr. Hari Kumar. He said, "It is not the government's role simply to arrest, try, and jail. Government's role is to ensure the rights of all citizens are protected, and that includes making sure that those who are accused have a fair hearing. Its KPI should not be the number of successful prosecutions, but rather that in every case, a fair and just result was achieved." He continued, "There have been cases of accused persons taking what they consider to be the easier path, pleading guilty to an offence they did not commit simply because they cannot afford the cost of a trial. And whenever we have cases of wrong convictions, it is a blight on our legal process and the administration of justice. And there is no higher cost than the indelible stain of a wrong conviction, particularly where the cost is one of lack of resources." So I agree with Mr. Hari Kumar's views. I also appreciate Minister Indrani Raja's response to Mr. Kumar's speech, where she stated that the government's KPI is not convictions. The government's KPI must be, and always has been, justice. Ms. Indrani had then replied that the government has received suggestions about a possible public defender scheme, and the government is reviewing the suggestion. I wish to commend the government for their funding support for the Criminal Legal Aid Scheme, or CLAS, which had given various degrees of assistance to persons charged with criminal offences and who require legal advice on criminal matters. Although it has taken some 9 years since Minister Indrani's speech, I'm glad that this bill has finally been tabled in Parliament. So I have some queries regarding the bill and hope that the Senior Parliamentary Secretary can address my concerns. Clause 4.5 of the bill states that despite any privilege arising out of the relationship between solicitor and client, a solicitor has a duty to disclose any information to the Chief Public Defender, or CPD, which may enable the CPD to perform his functions under the Act. Can the Senior Parliamentary Secretary clarify whether this requirement would expose the solicitor to an allegation of breaching his professional duty to the accused person? For example, if the solicitor obtains privileged information about the guilt of an accused person, does he have an obligation to inform or disclose to the CPD? Or can he simply seek a discharge as a solicitor if the accused person refuses to take his advice to plead guilty? Next, Clause 5.1 of the bill provides for the exclusion of a solicitor from the panel of solicitors. Can the Senior Parliamentary Secretary clarify whether such a solicitor can still act in a personal capacity if the accused person wants him to continue outside the public defender scheme? For example, if a solicitor insists on making frivolous applications to court and is eventually removed from the panel, can he continue to act as a solicitor for the accused person and continue with such frivolous applications? Clause 6 of the bill provides for the fees payable to the solicitor to be agreed. Can the Senior Parliamentary Secretary give an indication as to how fees can be agreed upon, because it is difficult for a solicitor to determine his fees without knowing whether such a trial would drag on for many days or even months? Or would the legal fees be determined after the trial is completed? So I urge the government to pay reasonable fees so that we can attract more talented solicitors to join the criminal bar. and that we will have then sufficient lawyers to ensure a fair administration of criminal justice. Sir, I understand that even for last go, the fees payable to the lawyers involved are very low and way off the market rate for lawyers of that seniority who do capital offences. Clause 12 of the bill sets out the process for grant of criminal legal aid. Can the Senior Parliamentary Secretary provide greater clarity as to the time frame for such aid to be granted? In practice, most accused persons have very little time to respond when they are charged in court. Frequently, the court allows the accused person 1 to 2 weeks to engage a lawyer before going back to court for the next mention. Would the Chief Public Defender be able to assess whether an applicant would meet the criteria for criminal defence aid within 2 weeks? In a situation where the accused is in remand, SPS had said that the family member can apply for criminal defence aid on his behalf. How much time would be required before the Chief Public Defender can assess the application for criminal defence aid if this person is in remand? The solicitor would presumably have to visit the accused in remand to determine reasonable grounds for defending. Would the state court allow an accused person a longer period of time to engage counsel if the person in remand is applying for aid? Regarding the means test referred to at Clause 12.1, how does the Chief Public Defender ensure that the rich applicant does not hide his income and assets so that he can receive the criminal defence aid? Would the Chief Public Defender investigate the declared sources of income and assets? Or will the Chief Public Defender simply rely on the declaration made by the applicant? I believe this point was previously made by Minister Shanmugam in Parliament, that the state should not finance the criminal defence aid of a rich applicant. For Clause 14.2, can the Senior Parliamentary Secretary clarify why aid should not be granted to more than one person in the same set of proceedings? Supposing there are 3 to 4 persons who are youth or juveniles who are accused of rioting and all deny responsibility for the offence, why should the CPD deny criminal defence aid to more than one applicant? Would it make any difference if the applicant seeking criminal defence aid intend to simply plead guilty? Why not allow the Chief Public Defender the discretion to decide instead of having a statutory bar to giving criminal defence aid to more than one applicant in the same proceedings? For the excluded offences under the schedule, while I understand the need to exclude the offences for most traffic offences or most regulatory offence, may I urge the Senior Parliamentary Secretary to consider allowing criminal defence aid to persons accused of dangerous driving, where the sentences may entail imprisonment of a few years. And these are not just regulatory offences. Before I conclude, I wish to refer to the speech made by the then Minister of Law, Professor Jayakumar, during the second reading of the Amendment Bill to the Legal Aid and Advice Act in July 1995. He was seeking Parliament's approval to delete Part 2 of the Act, and the Minister had said, the policy of the government is not to grant legal aid in criminal cases except for cases involving capital punishment. And in his speech, Professor Jayakumar has said that it is incongruous and inconsistent that public funds should be used to defend an accused person, which the state had decided ought to be charged in court, and to use public funds at the same time to get him off. So in the interest of transparency, since a public defender comes under the Ministry of Law and prosecution by the police comes under the Ministry of Home Affairs, may I ask the Senior Parliamentary Secretary to confirm that the Public Defender's Office will be given full independence to represent their accused in court without concern that the state is incurring public funds to prosecute the accused person? Can the Senior Parliamentary Secretary also clarify what brought about this change in the policy? So I support the bill. Thank you.